When individuals are likely to be in long-term need, whether it's because of a disability or their family circumstances, the Family Benefits Program is what they will try and access. And that's intended to provide long-term assistance to persons who are going to be in financial need. The Family Benefits is administered by the Ministry of Community and Social Services. The way it normally works is someone suddenly finds himself either unemployed or separated and without funds, and they first access the general welfare system, and then they get forwarded to the family benefits system if they're going to be in long-term need. The family benefits legislation came into place in 1966, and it combined a lot of different legislation that dealt with persons in need. There was a Deserted Wives and Children's Maintenance Act and miscellaneous other statutes, all of which were combined under the Family Benefits Act, and that was back in 1966. The general welfare assistance dates back to the 1950s. Both of them are primarily found in the regulations, so if any of you have to deal with family benefits or GWA, general welfare, my advice is to go to the regulations because the substance of the program is found there. It's not in the Act. The Act's very brief. It says if you're in need, you can get some help, and it doesn't really give you the detail. The regulations are where you have to look. The regulations change frequently. In times of restraint, the dollars go down, so you have to check them on a very regular basis. If someone were to qualify for family benefits as a disabled recipient, they have to meet the regulations say that they have to meet a medical test, so it requires some certification from a medical practitioner. Over time, there's been an expansion of eligibility as disabled by including in the description of disabled or permanently unemployable persons who have some medical disability, not necessarily a very serious one, but who are socially unemployable, low education, no work skills, no likelihood of obtaining employment, and they've expanded the category of persons who can qualify for family benefits by that way. Initially, it was meant to be medically determined only, but it's somewhat broadened over time. For someone on the family benefits program, it's important to emphasize that it's not a pension. Although many clients will speak in terms of their family benefits pension, it's not, and it's needs tested. So at any point in time, if a client comes into other sources of income, that other income takes priority, and the family benefits allowance is a last resort payment. So anyone on the program has to, on a monthly basis, although they don't report monthly, but in theory, every month when an allowance is calculated, you should have advised a worker, if you're on the program, whether or not you had any additional income or assets for that month. Children under the age of 18 used to be entitled to general welfare assistance if they were 16 or 17 and were disabled and not likely to be able to work. The regulations have been changed, so if a child's residing at home, a 16 or 17-year-old disabled child, they won't qualify for general welfare. But upon reaching the age of 18, they may qualify for family benefits. And that was a recent change. An important criteria for family benefits is, one of the large groups is the sole support parent caseload, but also the second largest group is the disabled, and the third is the aged category. Those are persons who don't qualify for old age security and other income support programs. But if a person's on the program, whether as a disabled child or a disabled spouse, they still have an obligation to pursue other sources of income that may be available. So if it's a disabled spouse, their spouse would have to be pursued for support. If it's a child, the parent of that child would have to pursue support for the child if it's available, whether under the Divorce Act or the Family Law Act. And that would depend on the circumstances of the family. There are some situations where a father, for example, is paying support for a disabled child, and when the child reaches 18, the father says he's eligible for FBA, I shouldn't have to pay support anymore. And the ministry has taken the position that no, family benefits, last resort, if in fact you're obligated in law to provide for the needs of your child, then that support obligation would continue. The ministry has provision in the regulations for taking assignments. So if someone has a support order being paid for their disabled child, but the support isn't coming in regularly, that support order can be assigned to the ministry, and then the ministry will pay regularly every month the allowance check, and then the support is assigned over to the ministry. One situation that may be of concern to you in a separated situation, if you have a spouse who's disabled, it's not so much the disability that is important, it's the fact that there's a separation and she's residing in the matrimonial home, and in many cases very large mortgage payments and tax payments are still being paid, and they exceed the allowance payable. The allowance amounts are not, I shouldn't editorialize, they're not very high. So if there's a mortgage, the average mortgage on a home will exceed the allowance that persons will be entitled to receive. That's income, and the ministry or the GWA offices have a policy of for 6 months after a separation, and where mortgage payments are still being paid, they will still allow a person to remain on the allowance despite the fact that the mortgage is being paid by the separated spouse. And that's to give parties a chance to adjust to a fairly significant change in circumstances. In terms of personal injury litigation, one more point, I'm sorry. Because family benefits is needs tested, that means we look at income and we look at assets. If you have regular income coming in, it's deducted from your allowance. If you have assets that exceed a certain amount, for a single disabled recipient, the asset limit is $3,000, so it's not very generous. But if you have assets that exceed that amount, in theory, you won't be eligible for family benefits. There are some exempt items, so you can have a personal residence, for example, which is not considered an asset. You can have certain trust funds, which I'll mention in a moment, which are not considered a liquid asset as well. But generally speaking, anything that you can convert into cash is an asset. There are some cases where it's not clear whether it can be readily converted into cash, and we deal with those on an individual case basis. If you're dealing with a family benefits file for a disabled recipient and they dispute one of the decisions of the ministry, the appeal route is to the board referred to as the Social Assistance Review Board, SARB as it's referred to. It's it's not as legalistic as the courts, obviously. There's very little exchange of documentation, and the decisions aren't binding on a precedent basis, but they're determined on a case-by-case basis. But SARB has jurisdiction to consider charter arguments, so it's a fairly significant board in that respect. They can hear charter arguments. They can't declare a provision of the regs to be not in full force or effect, but they can say for that individual before them, that regulation does not apply because it contravenes a charter. If you're a disabled recipient and you're on family benefits, if a member of the family or a friend dies and leaves you some money, that could disentitle you. So if you receive money outright, normal rule is it would cancel your eligibility for family benefits. You are permitted to have trust funds up to a certain dollar value. It's a $65,000 lifetime limit. So if someone were to leave you that money and it were to be placed in trust and used for certain identified items in the regulation, then it would not disentitle you. So a disabled recipient would continue to get their family benefits allowance. They can have up to $65,000 in a trust fund. It can be higher if there's some evidence given to the ministry to show that the needs of that disabled recipient are going to be very costly, and the fund can be increased with the director's approval. But you could put $65,000 in trust for that disabled recipient, and what it allows the trustee to do is to pay out of that trust fund for certain disability-related expenses. On the surface, it seems generous to leave $65,000 and allow access to the funds, but it's very restrictive when you look at the regulations because it has to be only disability-related expenses. So there's it's not what I should say, Mary Louise can probably agree with this, but it's not what was advocated by a lot of the groups speaking for the disabled, but it is intended to give some extra dollars into their hands for disability-related expenses. One thing it requires of the trustee is if one of these funds is set up, a $65,000 trust, the trustee has to file an annual report with the ministry detailing what the money was spent for, what it was spent on. Any money not dispersed from the trust will be prorated over the next 12 months and treated as income for that time period. There's one other form of trust fund which Mary Louise Dickson had a large part to play in, And it was a trust created in a will referred to, we call it the Henson Will. And I've made reference to it in the notes. In there, the wording of the will was carefully chosen to ensure that money was left for a child, but the trustee was obligated to exercise his or her discretion over the funds in such a way as to maximize family benefit. It didn't say family benefits, to maximize other sources of income. In our case, it would probably be family benefits. Those types of wills with that wording or wording that's similar are not considered liquid assets, and an individual would remain on family benefits despite being the beneficiary of one of these trust funds. On the issue of subrogation, just to mention very quickly, under health regulations, you have to notify them when there's litigation. For Ministry of Community and Social Services, there's no obligation in law to notify them. So if you had a client who was disabled and went through the Vocational Rehabilitation Services Program, for example, or who came on family benefits because of the disability, and you're suing on their behalf, there's no obligation in law to notify the ministry. But in the MCSS Act, Section 8, there is a right for the ministry to subrogate. So if the ministry gets notice of a case, we do take part in it. We either retain the plaintiff's counsel or we act for the ministry directly. And the ministry will recover for past costs as well as future costs. So they have a fairly significant role to play. Often the clients will tell their workers, who will then phone legal services. In some cases, the lawyers contact us directly and say, we're acting for Mr. So-and-so, who's a recipient of FBA. Is this going to affect their allowance? And we say yes. And then we become involved in the litigation that way. I focused on family benefits as one of the main programs that Ministry of Community and Social Services is responsible for, but there's also vocational rehabilitation services, which is to assist disabled recipients to reach the ability to engage in gainful employment. There are other programs, special services at home, a multitude of them, all of which the ministry provides. Some of them are on a needs basis, so there's expected to be a financial contribution. Others, there's no needs testing. They're available to anyone regardless of income, but their funding's limited. So it becomes a first come, first serve, or when funds run out, there's no more. The program just doesn't take on any new clientele. If you have any questions dealing with family benefits, whether it's litigation, family law, or anything related to that, estate matters, you can phone legal services, and there's a general number for the ministry, legal services, and there are lawyers who do litigation. I do the regulations, so if you're not happy with those, you can phone me. And there are other lawyers who do the family support applications and arrears, and they can deal with you directly.
Thank you, Marilyn. I'd like to just say a few words about estate planning, where a dependent is disabled. I think when you're talking estate planning, you're talking about a complete many facets of financial planning for dependents who have special needs. And I usually think of them in two categories: those that are physically disabled but mentally capable and who can work. And generally, in that case, special planning is not required. The same sort of planning that we do for any client applies to the disabled who are mentally capable and can work. And then there are the individuals who, for one reason or another, have either mental capacity problems or difficulties, either physical or mental, and can't work. It can be by a number of causes: age, senility, it can be autism, schizophrenics, and then, of course, the developmentally disabled. And if you have someone in your office who tells you they have a beneficiary who falls in the latter categories, Planning, I guess, falls into several sort of areas. There can be lifetime planning, and generally, I advise parents not to set aside assets for a disabled child or other dependent as long as they're capable of providing for them, unless there's special circumstances, such as divorce, where they want to sever ties between the spouses and make arrangements for the ongoing needs and care of the disabled beneficiary on a once and for only basis. Otherwise, I really believe it's better for the person who is the supporting person to retain control over their assets, because they can adjust as circumstances alter, whether it's because of the situation of the particular beneficiary or government programs. Now, if you're going to do planning at death for a client, you're usually talking about will planning. And obviously, as lawyers, most of us know that all people should make a will. If you don't have a will, the government has made one for you in the intestate laws, but the property is divided in accordance with the statute on prescribed divisional basis. It's all set out in the Act, and the spouse gets the first $75,000 plus a percentage of what's left, and any children share a certain amount. And if there's a disabled beneficiary, theirs is paid into court, or a committee must be appointed for ongoing management. And that's usually not satisfactory. So you're usually looking at a will for such a person. And in the will, you can do a number of things. You can appoint an executor to manage the person's assets. And this is very important. You can either name an executor who will carry out the initial administration and the ongoing trusts for the disabled person, or you can name one person as executor and another as a special trustee of the share that's set aside for the disabled person. And there's a significant difference. If someone is appointed the executor, they have certain prescribed duties in law, and the fees are set by the courts, but have become formalized at roughly 5%, 2.5% on income and capital receipts, and 2.5% on income and capital disbursements. And if you have a beneficiary, say, who's disabled and will be entitled to, say, 1/3 of the estate or 1/4 of the estate, and fees are a concern, if you appoint a family member or a group of people or a professional trustee as executor, they carry out all the basic administrative functions and charge their 5% or not charge it, as the case may be. But then they turn over a check to the trustee who will administer the trust, and that person's fees will be significantly less. And I think this is an important point to consider sometimes in the case where they want ongoing management on a professional basis and are prepared to pay for it, but realize they can save roughly 4% by doing it in one way as opposed to another. Now, when you come down to the terms of the will, I usually approach it with clients on the basis of, do you want to support your child yourself, or do you need the family benefits? Until recently, there was no joint sharing in Ontario of the care of a disabled beneficiary. And it appears that the first step has been taken by the government towards a joint sharing with the introduction of the $65,000 trust that Marilyn's described, though this has limitations. Now, if the parent wants to support the child themselves, then you plan for that person as you would any other, except you may want the capital held in trust during the beneficiary's entire lifetime, rather than paying it out when they reach the age of majority or 25, as you would in many cases where there's no problems concerning the beneficiaries. If the parent tells you they need the family benefits, or if the lifestyle of the beneficiary cannot be improved by having the parents look after the person themselves, and you need to plan around the benefits, then you have to keep in mind the provisions of these benefits. And the main rule is that the individual cannot have more than the $3,000 or they'll lose their benefits. And what we did in the past was set aside part or all of the estate in trust and give the trustees discretion how much to pay the child out of income or capital, and they could pay the child all of it, some of it, or none of it. And because the child had no rights to sue for any amount, and it was entirely in the discretion of the trustee, then the child, merely by being a beneficiary of the trust, was not disentitled to the benefits. Now, if anything was actually paid to the child out of the trust, then that could be considered a source of income and would be taken into account in determining the entitlement of benefits, unless, as most often would be the case, it was paid out for items that are prescribed in the legislation to be allowed, such as a residence for their own use or small comforts. Now, there's the new $65,000 trust that Marilyn spoke about, and it appears that the legislation will now allow that amount to be set aside, and the income can be directed to be used for the prescribed purposes for the child without discretion. In other words, you'll be sure that the funds will be available for the prescribed purposes. The difficulty with that, as I see it, is that very few of the clients I deal with, or the beneficiaries of the clients, need assistive devices or medical care that isn't covered under a program. You may have a client that is physically disabled and needs a van or something, and this might be useful. But on the other hand, you can probably in the future combine the two trusts and use the concept of the discretionary trust and combine it with allowing it to be spent on the prescribed amounts, and then the benefit of the person. So that's the sort of thing you should be thinking about when you plan for a disabled person. I believe I could say a few words on whether a disabled person can make a will themselves, and the answer is they can if they have capacity, and what to do if they do inherit assets and can't manage it. Under the new $65,000 trust, they would try and set it up in this form of trust and preserve any government benefits they were entitled to, as well as their ability to benefit under the funds left by the family. Thank you. And now I'll turn it over to Sharon Cohen. will expand on the support aspects.
Practice family law and have done so since my call to the bar in 1990. And I have had the opportunity to work with many disabled clients in my years of practice, and I think that relates to my original training way back in 1966 as a physical and occupational therapist. I also think it probably has to do with the fact that I practice with Louise Dickson, and she has certainly extensive networks in the disabled community, and so I get called in to assist with several cases that she may know of, or I get them referred to me directly. I've tried to set out for you in the handout that I've provided an overview of the legislation that applies to family law in general, and I've tried to highlight for you some specifics in the system of practice of family law that I think might be particularly noteworthy with regard to the disabled client. And I don't want to spend too much time talking about what is already in the handout, because I think it would be more fun for me, certainly, to discuss with you the particular challenges in reference to some specific clients that I've worked with. As far as the practice of family law generally, the whole area of spousal support and child support is one in which the legislation is set out in such a way that the courts are awarded a great deal of discretion. And therefore what happens is it's a very unpredictable area of practice. So one settles most things out of court, as with any kind of litigation, but especially in family law, because no one knows what you will get very much if you go before a judge. So it is definitely a crapshoot to go, and therefore most lawyers, since we know that, we try to settle everything we can. The legislation itself tends to speak out of both sides of its mouth with regard to the area of spousal support. Section 30 in the Family Law Act sets out an obligation to that each spouse is expected to provide support for him or herself and for the other spouse in accordance with that spouse's need and the payor's spouse ability to pay. So as you can see, right off the bat, there's a double responsibility. It's that everyone is expected to be self-supporting, but that to the degree that they are incapable of doing so, there is an obligation on the other spouse to support that spouse. And this has led to incredible pendulum swings over the past several years. The new legislation that exists now has been in effect, the Divorce Act since '85 and the Family Law Act since '86. And that was to try to bring us into the 20th century in terms of relationships and the degree to which marriages now end in separation or divorce. There's a huge number of people out there for whom all of this applies. And the whole notion now that we do not have traditional marriages, most people are working or take time off to raise a family and then go back to work. It was an attempt initially to try to recognize that being married was not a pension for life for either spouse, and that people do have responsibilities to be equal partners. So after this legislation came into being, there was an immediate sort of area where women were expected to be self-supporting, and as the dependent spouse, after separation, were given time-limited support awards, as well as what occurred was a whole issue of they're only entitled to support from the other spouse if there is a causal connection between their inability to work and their dependency and to the marriage. Well, this, as you can see, would lead to a lot of difficulties with regard to a disabled spouse, because it would, in most cases, be very difficult to demonstrate that any economic dependency related to the marriage when there's a disability involved. That doesn't mean people didn't try. So that meant that you would then get into a rather ugly scenario where people were blaming their disabilities on the stress of the marriage and so on. So all of this doesn't lead to a lot of happy litigation. I think if we turn to page 3 of my handout, Fisher seems to be the leading case now, which in essence is also going the way of the case law generally, in that there is no longer, to find help from a spouse, it is no longer necessary to prove that the dependency is causally connected to the marriage. Now, you'll notice down, 2 cases down from that, the case of Wilms. Although that's an Ontario Court of Appeal case, and Fisher is a divisional court case, leave to appeal Fisher to the Ontario Court of Appeal was denied. So with regard to the Wilms case, we can distinguish that on the facts in that it was a 10-year marriage, there were no children, separated many years before it came back again in front of the courts. And the wife had emotional problems and was going to be ultimately spending the rest of her life in an institution for schizophrenia. So I think the courts in that case, based on the facts, were more willing to say that, in fact, the husband's off the hook because the reason for the dependency was not causally connected to the marriage. The other case that I'd like to point out to you that's of some interest is on page 4 of the handout, and that's the case of Smithson. One of the criteria to determine support obligations has to do with the assets of the parties. In other words, if you have enough assets, either on your own or as a result of a division of assets on separation, then you may not have a need for support. And the court in Smithson was willing to get somewhat creative, and what they did was they terminated support, but in fact what they did was they made an unequal division of the parties' assets. It may be then said, which was a creative, I think, solution to also allow the parties to get on with their separate lives because it's a clean break, which is also another consideration that the courts use into how they make the determination of ongoing support. The case Herber down below, right below Smithson, there's a typo in my notes. That's a 1992 case. And it's also a British Columbia case, and it's Court of Appeal. And it seems to state pretty conclusively there that property under the guise of support is improper. So I suspect that we won't be able to rely on courts using that kind of creative solution sometimes to an ability for spouses to get on with their own lives.
Acknowledge the additional non-discretionary personal costs associated with having a disability. And there are several people who would argue that these provisions are not fair enough or not generous enough or not both, and I'm among them. But the fact remains that the rules that we do have in the Act are much better than they once were, and there have been a lot of changes just in the past 5 years that have added to them. But the way that the provisions have been amended have resulted in a long and fairly bewildering list of specific items, conditions, requirements, and lists and lists and lists. And I have a cartoon which I want to project on the overhead, which gives some indication of how bewildering the rules are. And I know you can't read it, but maybe you can't see it, but it's a picture of 2 men, and they're visiting a museum, and they're looking at some hieroglyphics etched in stone, and one of them is saying to the other, I can't read it. I can read it, but I don't understand it. It seems to be a primitive form of the Income Tax Act. And that applies very well to the rules for disabled taxpayers and their expenses. You just switch that on. Thank you. Determining the tax credits available for those who are cared for in institutions is relatively easy. The hard part is figuring out the rules applicable to those who live at home, and because they're much more complex and the tax concessions are more limited. The income tax provisions that I'm going to look at are the special personal tax deductions and credits available to a disabled client and his caregivers, his or her caregivers. There are also other provisions in the Act which allow employers to provide benefits such as attendant care, transportation, parking, etc. on a tax-free basis, i.e. as tax-free benefits. There are other provisions that allow employers to write off 100% workplace modifications to make them more accessible rather than to capitalize them and take CCA. And these are discussed in my paper, but I'm not going into them. At the center of most of the provisions in the Act for disabled taxpayers is the disability tax credit. In 1993, the credit is worth $4,233, but that's at 17%. It's really worth $720 federally and approximately $400 more in Ontario, so a total of about $1,100. But one of the really important parts of this credit is that if you're an individual who qualifies for this credit, you're entitled to other preferential treatment under the Act. Only individuals eligible for the disability tax credit are eligible for certain additional claims for medical expenses, for more generous child care expense provisions, for the $5,000 attendant care deduction, i.e. if you need an attendant to go out to work, there's a maximum $5,000 deduction if you're eligible for the disability credit, and also for those tax-free benefits. To qualify for the disability credit, an individual must have a severe and prolonged mental or physical impairment, and it has to be expected to last for a continuous period of 12 months. The effect of the impairment must be such that the individual's ability to perform a basic activity of daily living, and that's defined in the Act, basic activity of daily living, has to be markedly restricted. The form is a T-2201, and it's signed in most cases by a medical practitioner, but if there's visual impairment, it can be signed by an optometrist. It's usually filled out once, but if conditions change or Revenue Canada requires a new form, requests a new form actually, you may have to file a new one. And it has to be filed in the return of the person who's claiming the special credits or whatever related to the disabled individual. To qualify for the disability credit, the condition must be so severe that at least 90% of the time, even with the aid of therapy, the use of appropriate devices and medication, the individual is blind or is unable or requires an inordinate amount of time to perform a basic activity of daily living. Those basic activities of daily living are defined in the Act. They're also listed in my paper. What's notable, though, is that no activity, including working, housekeeping, or social or recreational activity, is considered a basic activity of daily living. So it's very, very restricted. If a disability credit is claimed, the cost of a full-time attendant or a nursing home cannot be claimed as a medical expense. So it's either the disability credit, that $4,233 credit times 17% grossed up provincial tax, either that or the cost of a full-time attendant or nursing home. And usually if you have those types of expenses, they're more than $4,233, and you claim larger amounts. Like most personal tax credits, the disability credit is non-refundable. That means that it can be only used to reduce tax. If you don't pay income tax, you don't benefit from it. The refundable GST credit, refundable versus non-refundable. The refundable GST credit, on the other hand, is income tested and is a refundable tax credit. It's paid to people who owe tax and people who don't. The good news is the disability credit is transferable. That is, it can be transferred to, if the disabled individual doesn't need it, it can be transferred to his spouse, his parent, his child, if they support him. The other big tax credit for disabled individuals would be the medical expense credit. Medical expenses for which a taxpayer hasn't been reversed either under the programs provided by ComSoc or by medical plans, say, of his spouse or parent. The list of medical expenses is very long and unwieldy, and lots of additions have been made to this list in the last few years, keeping up with technology and patterns of use. The list of medical equipment that's allowed contains specific exclusions, for example, air conditioners, humidifiers, dehumidifiers, even if they're prescribed by a doctor, even if they're special purpose. Can't claim them. And that's even in the case of someone with a severe chronic respiratory or respiratory ailment or immune deficiency. So you have to really consult the list of medical expenses in the Act and in the regs. Medical services, as you probably know, are included in the list of eligible medical expense, and that includes services provided by doctors, nurses, dentists, hospitals, payments for tests, and more recently, payments for rehabilitative therapy such as training in lip reading, sign language. Nursing home or institutional care can be claimed if the individual qualifies for the disability credit, and with one exception, if the cost of a full-time attendant isn't claimed. So it's an either or in most cases. The only exception is if the disabled individual is certified by a medical practitioner to have lack of normal mental capacity and therefore is dependent upon others for personal needs, etc. If an individual qualifies for the disability credit, the nursing home costs that can be claimed as a medical expense not only include the medical services, includes everything, okay, except for such personal expenses like hairdressing, but it would include food, accommodation. So not just the medical care provided by doctors and nurses, but virtually everything except for things like hairdressing. Revenue Canada doesn't require nursing homes to be licensed for this claim, but there must be sufficient medical personnel to have high caliber of service and service to residents on a 24-hour basis. And it's for this reason that self-contained apartments used by seniors and some disabled individuals may qualify under this provision if they have that level of service. Contrast this to the item in the list of medical expenses, which is for care and training in a school. For this provision, you don't have to be eligible for the disability credit. And this can be claimed as long as the individual who required the care needs the specific facilities provided by the place. Revenue Canada, this is the provision that allows a medical expense claim for special schooling for, say, a disabled child or a day program for a disabled adult. But Revenue Canada will question the claim if it's not a medically based school. So if the child is going to a school where he's integrated with non-disabled persons, it'll be questioned. The list also includes a multitude of other items, including equipment and services, transportation costs, traveling costs, home renovations, and alterations, and these are all in my paper. I also go into, in my paper, alternatives for claiming attendant care expenses, either as a medical expense, a expense deductible under the $5,000 deduction under Section 64 of the Act, where it's incurred to earn income, as an employment expense, and as a child care expense. In summing up, what I hope to have done is to leave you with a taste of the complexity and the unfairness of the tax rules providing tax benefits to disabled taxpayers, and provide, despite the many improvements made to the Act for their benefit, the tax relief currently available is not straightforward and is not always fair. Low-income individuals who have to pay their own medical expenses because they aren't paid for or reimbursed through a program provided through social assistance or their spouse's program, they're only able to claim a 17% credit federally for these items, and some of them aren't eligible. And if they don't owe tax, there's no tax relief at all because they're not refundable credits. Also, individuals who are eligible for the disability credit and live in institutions are eligible to claim the entire cost of their care as a medical expense, while those who live at home are often eligible only for some limited deductions or credits for these services. The list of medical services and equipment eligible for claim are restricted to a long, complex, and detailed list of items to ensure that those who are not disabled do not benefit. But really, you wonder sometimes, is it really helping disabled taxpayers? Thank you.
Hello, my name is Jim McDonald. If you've just got the binder materials, you'll wonder what I'm talking about because I didn't prepare any materials, and I apologize for that. What I'm going to talk about are disability policies. And disability insurance policies are policies that are distinct from sickness or accident policies. It's distinct from a no-fault automobile insurance policy. They're sometimes referred to as long-term disability policies, or sometimes referred to as weekly indemnity benefits. But it's effectively an insurance policy that's prepared by and issued by and marketed by insurance companies. I'm not here to comment on the ethics or the morality of the insurance industry, although there's certainly been enough comments about that. I would refer you, though, to an article which is going to be published in the Journal of Law and Social Policy It's an article entitled "The Industry of the Living Dead, a Critical Look at Disability Insurance." It's by David Schulze, and it'll be forthcoming shortly. And he provides a very critical look at the industry and the marketing of these policies and the administration of these policies. And his article would be a valuable source for anybody who's involved in litigation with an insurance company over a long-term disability policy. I'm also not here to tell you how to draft a policy. I don't know how. Our firm only represents employees, and we don't draft these policies. And most lawyers are never going to be in a position to draft these policies because they're effectively given to you by an insurance company, and you either take it or leave it. What I would like to talk about are some practical aspects of representing an individual who is having difficulty collecting payments or receiving payments on his or her disability policy. And I state that firstly, that the claim is a claim that is based on a policy. There are no statutory terms for these policies. The claim is based on a policy. And there are two basic principles in considering representation and considering advice that you give to an individual. The first basic principle is that the provisions of a particular policy govern the matter. In other words, regardless of what the general law is, you have to look at the provisions of the particular policy. The second basic principle is that the burden is upon the insured, in other words, the individual claimant, to prove that the individual claimant was entitled to the benefits as defined in the policy. I'll mention later about where there is a possibility of a shifting onus of proof, but those two basic principles are what have to underlie you in determining the advice that you give to your client. I will just refer you to a couple cases. I'm not going to give you the complete site, but I'll just tell you the name of the case and the date for where you look to see where these principles are set out. If you look at Porter, it's a 1985 case, or Sukharov, S-U-C-H-A-R-O-V, a 1981 case, sets out these two basic principles. How then do you approach the situation in terms of collecting information, determining advice when an individual comes into your office? The first question you have to ask is, when did the injury, when did the illness, when did the accident occur? And that is relevant for a number of reasons. One is that there is a real issue of timeliness. And there's two aspects of the issue of timeliness, and one is giving proof of claim to the insurance company, because most insurance policies have a time limit for providing a proof of claim in a form that's acceptable to the insurance company. And then the second aspect of it is that there's a limitation period for bringing a claim against an insurance company where the insurance company is denying payment of benefits. So you have to establish, firstly, when was the date of the injury or the illness or whatever that caused the loss of employment or the interruption of earnings that gives entitlement to the disability benefits. An interesting aspect of that is that one way of beating this timeliness, and I'll just refer you to this interesting case, which found that there has been found by a court in Ontario that there's a duty upon an employer to advise an employee that the employee is or might be entitled to disability benefits. Some of you might be interested in looking at the case of Tarailho, T-A-R-A-I-L-H-O, a 1989 68OR case, where the court found that the employer had this duty. The court said the employer is the one who's got the proof of claim forms, the employer is the one who's got the policy. It's up to the employer to tell the employee that the employee might have a claim. So that's one way of possibly beating a timeliness problem. But the first information you have to obtain is, when was the interruption of earnings? When was the date of the illness? The second piece of information, which I think is crucial, is you have to ask, is the person a unionized employee or a non-unionized employee? And that piece of information is crucial for three reasons. One is that if the person is a unionized employee, the union can be helpful in assisting you and assisting the individual in pursuing the claim. And not all unions, but some unions will fund individuals who have claims against insurance companies based on a disability policy. And also the insurance company is valuable as a source of, the union is valuable as a source of information, in that the union is likely to have the copy of the policy, whereas when an individual comes to you, in almost all cases, the individual will not have a copy of the policy. A second reason why it's important to know whether the individual is a unionized employee or not is because if the individual is a unionized employee, a claim arising out of the non-payment of long-term disability benefits may be restricted to a claim based on the collective agreement and may be restricted to a grievance as opposed to a lawsuit. There's a long-standing body of law, indeed it's in the Rights of Labor Act, that where a right arises out of a collective agreement and is limited in the collective agreement, that any action based on a breach of that right or denial of that right is limited to the procedure set out in the collective agreement. So you have to know whether they're unionized employee or not, and determine if there is a dispute where you're going to go on the dispute. And indeed, if there's a collective agreement, there's often time limits in a collective agreement for filing a grievance. And a third reason that you have to look is because if the benefit is provided for in the collective agreement, you have to determine, after looking at the collective agreement, whether that benefit is one that the employer is liable to maintain or whether it's one that the insurance company is liable for. And there's a distinction in the case law in terms of whether in the collective agreement the employer merely agrees to provide for the payment of premiums for the policy or whether the employer agrees to actually provide the benefits. If the employer in the collective agreement has agreed to provide the benefits, then if the benefits aren't paid, the breach can be dealt with through the grievance procedure. If all the employer has agreed to do through the collective agreement is provide for the payment of premiums to an insurance company, so long as the employer has paid those premiums, then the employer has honored its obligations, and any action based on the long-term disability policy becomes an action against the insurance company. And one interesting case you might look at if it comes up is a case of Bull and Realty. It's a 1981 Ontario Court of Appeal decision where an individual was fired in the individual's claim for damages for wrongful dismissal. The individual claimed not only the regular sort of compensation in lieu of notice, but also claimed for payment of long-term disability benefits. And the Court of Appeal said, well, no, the employer wasn't on the hook for the long-term disability benefits. It was the insurance company. And even though your employment was terminated, you should have made your claim against the insurance company, and the employer's not liable to you. So you look to see whether you've got a collective agreement. You look to see what time when it was that the injury or the illness occurred. Then you try and get a copy of the policy. If you can get a copy of the policy, you look at the copy of the policy, but we'll get to that in a moment. In terms of the type of information that you want to collect, I'll just list the kind of information you want to collect. You want to collect any and all copies of any medical reports that the individual might have. And most people, by the time they're making a claim for long-term disability benefits, have got a rather extensive history of illnesses or injuries or accidents, and they've been to see generally more than one doctor, and they've also generally provided medical reports to either the employer, the Workers' Compensation Board, or somebody else. You want to collect all you can in terms of copies of those medical reports, not just related to the current injury, but also related to the previous injury, any previous injuries. You also have to collect and make sure that you get copies of any notes that the individual might have given to the employer, because most employers require doctor's notes whenever there's an illness or an absence, and you want to make sure you know what the doctors have been telling the employer. So you collect as much information you can about the past medical history as documented in the form of medical reports or doctor's notes. You also, of course, have to get a medical release, from your client, signed by your client, and a lot of copies of it, because you're going to be sending it out to a lot of people. You also have to obtain a job description, and as detailed as possible a job description, and the sources that you look for to obtain a job description are the individual's hiring contract or contract of employment if the individual has one, any job posting that might have been raised by the employer at the time that the individual got the individual's current job, any performance appraisals that the individual might have received. They often include pretty comprehensive information about the demands of the job, pay equity material that has been generated by the employer, because you can look at that to determine what are the physical demands, the mental demands of the job, or you look at a collective agreement. Some collective agreements actually have job descriptions in them, although generally they don't. And you, again, can go to the union if there's a collective agreement, because the union has often been provided with copies of job descriptions, even if they don't accept them from the employer. The reason you have to know about the job description is because at some point you're going to have to make an assessment of the duties and responsibilities of the individual in the individual's current job, plus all the demands, physical, mental, stress, repetitive strain type of demands that might flow from a person or might be incumbent upon a person who's expected to perform those duties and responsibilities. A third piece of information you need is a resume from the individual with a very detailed background as to the type of the training, the education, the experience that the individual has acquired during the individual's lifetime. If there's no collective agreement, you want to look at a benefit booklet. Most employers now provide employees with benefit booklets that at least provide a summary of the insurance policy and a summary of the crucial terms of the insurance policies, but you can't rely on a benefit booklet. The benefit booklet is generally, although it is prepared sometimes by the insurance company, it's not the policy. And it's the policy itself that is the basis of your claim. And another piece of information which you want is any and all copies of earlier correspondence between the employer and the employee, or the employee and anybody else, such as the Workers' Compensation Board. When you have all of this information, you're in somewhat of a position to advise the individual as to the individual's rights. Firstly, you have to and should be advised the individual that even though they might be disabled and entitled to disability benefits pursuant to one of these policies, they have still a right to continued employment or possibly a right to re-employment. And in order to provide that advice, you're going to have to look at the terms of the collective agreement, decide what it is in the collective agreement that gives the employer the right to terminate someone's employment. You're going to have to consider the principles of wrongful dismissal law, which distinguish between a temporary disability, even if it's a total disability, a temporary total disability, and a permanent total disability. There's only just cause for terminating the employment of someone who's permanently totally disabled, not temporarily totally disabled. You have to consider human rights legislation, the duty to accommodate, because disabled employees who are entitled to disability benefits are also entitled to have their disability accommodated by the employer. And you also are obliged to consider the implications of the workers' compensation legislation, because many employees are in situations where they've been entitled to benefits because of workers' compensation. Which is another problem that often arises in terms of this timeliness issue, because many individuals file a claim for workers' compensation benefits and don't file a claim for long-term disability benefits, and even on many occasions get paid workers' compensation benefits by their employer, or get paid the equivalent of workers' compensation benefits by their employer during the period of time that the Workers' Compensation Board is considering the claim, and then have their claim disallowed, and then find themselves out of time for filing a claim for long-term disability benefits. Long-term disability benefits are not predicated on any particular cause, whereas workers' compensation benefits are clearly predicated on a claim arising out of an accident that occurs out of or in the course of employment. But you have to consider the implications of workers' compensation legislation anyway. So you advise the individual as to the rights as to continued employment or re-employment. You also advise them that their entitlement to long-term disability benefits will continue even if their employment is continued. Even if their employment is discontinued or their employment is terminated. In other words, if the individual has a claim for long-term disability benefits that arises during the course of the individual's employment, that claim continues even though the employment is terminated. You have to also advise the individual as to possible claims for or other sources of income, for a number of reasons. One is because LTD policies generally require employees to file claims for other sources of income. Secondly, the source or the receipt of other sources of income is going to affect the level of LTD benefits, because most LTD policies provide for a set-off, either a 1-to-1, $1 for $1 set-off, and a reduction in the LTD benefits, or a maximum amount of benefits that can be received from all sources while on LTD benefits. Excuse me. So you have to advise them as the other possible claims or sources of income. And those possible claims or sources of income are from the Workers' Compensation Board, from the Canada Pension Plan, and the Canada Pension Plan provides for disability benefits. And it's important to understand that individuals may be entitled to disability benefits under a long-term disability policy, but not entitled to disability benefits under the Canada Pension Plan. Canada Pension Plan provides that you're entitled to disability benefits only if you have a severe and prolonged mental or physical disability, which is of indefinite duration and which renders you incapable of regularly pursuing any substantially gainful occupation. So you may not be, the individual may not be entitled to CPP disability benefits, but will still possibly be entitled to benefits under an LTD policy. But you have to advise them of that. Indeed, in many long-term disability insurers require the individual to apply for CPP benefits, disability benefits, even if they're not going to receive them. There's also automobile insurance benefits, or automobile accident benefits, no fault and otherwise, or otherwise the employer or the LTD will require you to, insurer will require you to apply for those. There's also the sick leave provisions that an employer has, because generally disability policies are issued to be complementary to an employer's sick leave policy. And they generally kick in only when an individual has exhausted the sick leave benefits that the individual has directly with the employer. So you have to make the individual aware, you yourself have to become aware of what the employer's sick leave policy is. You also have to consider wrongful dismissal damages that the individual might be entitled to. And there are some interesting cases that have dealt with the interrelationship between entitlement to long-term disability benefits and the entitlement to wrongful dismissal damages. The Bull case, as I referred you to earlier, was one. McGee, which is a 1986 Ontario Court of Appeal decision, is one where the Ontario Court of Appeal held that if an individual is given a period of notice, the individual becomes disabled during that period of notice and becomes entitled to LTD benefits during the period of notice, then the period of notice in effect is suspended during the period of disability and takes starts to run again after the individual has over the period of disability and is able to be in a position to look for employment. There's an analogous case in British Columbia called Dunlop, 1988 case in British Columbia. And there's an interesting issue as to the obligation of an employer to continue to cover an individual for LTD benefits even during a period of notice, even when the individual isn't employed by the employer. In other words, if you have somebody who becomes disabled after they've been fired, but during their period of notice, that individual may have a claim against the employer for long-term disability benefits that they would have been entitled to if they had been working. Those cases all have to be considered in the context of the Supreme Court of Canada decision in Ratish and Bloomer, where the Supreme Court of Canada has held under many circumstances individuals aren't entitled to what the Supreme Court of Canada considered to be double recovery or double benefits. And Mr. Justice Lissick, in a case in BC, Prince 1990 decision in BC, has found that you don't get LTD benefits during your period of notice because that would be double recovery. You'd be getting both LTD benefits and severance pay. In any event, you have to consider wrongful dismissal damages. You also have to consider retirement benefits, what the individual might be entitled to under early retirement policies or provisions. Assuming that you have a policy and assuming that that you've considered all of these, what do you expect to see in a policy? Firstly, the structure of entitlement is usually, you firstly have to determine whether the individual is entitled to any benefits at all. Not all employees are entitled to LTD benefits. There's generally what's called in a policy an eligibility waiting period. And it may be 3 months. It may be until the individual has fulfilled or completed a probationary period. But there may be a waiting period if the individual became disabled. During that waiting period, that's a ground for denying benefits. The individual may have been a part-time employee, may not have worked a sufficient number of hours to qualify for benefits. Most employers, or many employers with collective agreements, provide for payment of a lump sum amount in lieu of coverage for benefits such as LTD benefits. You also have to consider whether the individual was in active employment at the time that the individual became disabled. And the policy itself generally defines active employment. If the individual was on a leave, the individual might not have been covered for these disability benefits while they were on leave. If they were on holidays, they generally are. If they were on layoff, they might or might not be, depending upon the terms of the collective agreement. If they were seconded to some other job with some other employer, they might not be entitled to benefits. You also have to consider whether there was an earlier plan in order to determine whether there was coverage. Many employers are now getting into a situation, and we had a grievance involving an individual where the individual was off on layoff, and the employer switched policies, changed carriers. The individual then went back to work, and the new carrier refused to cover the individual, and because the individual failed the medical examination, and took the position that the individual wasn't then covered for benefits when it came time for disability. You have to consider whether you have then a claim against the employer for failing to maintain that coverage and for in effect changing carriers to the prejudice of the individual. You also have to consider whether there's an elimination period, and this is in the context of what I described as this complementary nature of sick leave benefits and long-term disability benefits. Generally, individuals aren't entitled to long-term disability benefits until they have completed this elimination period, which is either a certain period of time in some policies, 6 months, or tied to the expiration of sick benefits. Then the major issue then becomes total disability. And because that is the concept that is a driving force behind disability benefits, the individual must be totally disabled. And totally disabled is defined in policies. And one has to look at the policy because policies are not uniform in how they define total disability. And the insured, as I stated earlier, has to bring himself or herself within the definition of total disability. I just refer you to a decision of Mr. Justice Laskin and Paul Revere, and that was in the Sukharov case that I referred to earlier, but at the Supreme Court of Canada level. And Mr. Justice Laskin's definition in total disability in Paul Revere is used in interpreting many and most of these policies. And Mr. Justice Laskin said, in other words, total disability does not mean absolute physical inability to transact any kind of business pertaining to one's occupation, but rather that there is a total disability if the insured's injuries are such that common care and prudence require him to desist from his business or occupation in order to effectuate a cure. In many cases have relied upon that definition, which is one of the most liberal interpretations for employees' purposes of total disability in insurance company policies. Most insurance companies' policies distinguish between total disability during the first 24 months of the claim and total disability thereafter. Employees are generally entitled to benefits during the first 24 months, and I'm reading from the City of Toronto policy, if their injuries or disease prevent the employee from performing any and every duty pertaining to the employee's normal occupation. In other words, it's generally during that first 2 years, it's a provision that says so long as you can't do your own job, you're entitled to benefits. After the 2-year period, and this is why job descriptions are important, this is why resumes are important, this is why training qualifications are important, that after the first 2 years, the policies generally liberalize or sort of expand the occupations or positions that the individual would be incapable of performing in order to find that the employee is entitled to benefits. The City of Toronto says after the elimination period, then the total disability is one that prevents such employee for compensation or profit from engaging in any occupation and performing any work for which the employee is reasonably qualified by education, training, or experience. In other words, it's not own occupation, it's any occupation that the employee is reasonably qualified by education, training, or experience. I think I'm running out of time here. All I would say is that if you're looking, and this is the primary issue that comes up in disability claims, where the insurance company takes a position that the employee is not totally disabled. If you look at the CEDs, or if you look at the Canadian abridgments, you will find countless cases that deal with the definition of total disability. And rather than go through any of those cases, I think that I'll just direct your attention to those sources. But again, caution you that the claim is always based on the language of the policy. And I take you back to where I started, which is saying that when you're dealing with long-term disability claims, there's two basic principles. One is you have to look at the policy. You have to get the policy and interpret the policy. And secondly, the onus is going to be on your client to establish that your client does come within the terms of the policy and that does thereby become entitled to long-term disability benefits. I think that completes.
Thanks, Jim. And I'm going to conclude by making a few remarks about Canada Pension Plan, or CPP Disability. In your materials, the first two tabs are very extensive memoranda on CPP Disability prepared by the CRO. I just realized now in looking through that there's nothing that explains what the CRO is. It's perhaps worth mentioning. It's the Clinic Resource Office, which is the specialized research facility for the community legal clinics, of which ARCH is one. The Clinic Resource Office has a lot of expertise in the various kinds of poverty law, family benefits, Canada Pension, workers' comp, and the like. Well, it's primarily established for the clinics. If you're acting for legally aided clients who have problems in these areas, you could access this facility as well. I'm not sure the extent to which you can access the facility for other cases, but I think you could, perhaps at a cost, obtain at least the standard memoranda. Now, with regard to CPP disability, since Canada Pension Plan is largely thought of as a retirement plan, often you will find that your clients are not aware of the prospect of making a CPP disability claim at all. And for many of your clients with a disability, regardless of the context in which they come in to see you, workers' comp or family law situation or whatever, income is going to be a major issue. And CPP is one of the things that should be on your checklist to discuss with your clients. In fact, there are some contexts in which your clients may, in a sense, be required to apply for Canada Pension Plan disability. The Family Benefits Act, which Marilyn Marshall discussed earlier, contains a requirement that people receiving family benefits try to actualize other potential sources of income, and one of these is Canada Pension. In fact, the Ministry of Community and Social Services is right now undertaking an initiative to encourage people receiving family benefits from the provincial government to apply to the Canada Pension Plan for disability payments. And that has sparked a lot of calls to our office about CPP disability. Of course, as between the two plans, family benefits is the secondary payer. And if the client receives Canada Pension disability, it's then deducted from the family benefits. Similarly with long-term disability, which Jim just covered, most long-term disability policies require the individual to apply for Canada Pension Plan disability as well, which is usually deducted from it. And I'm going to discuss the two main items of eligibility, which are largely in the substantive law memorandum at tab 2. I'm not going to discuss the appeal process because of time limitations. But for the definition, first of all, are you disabled enough? And like long-term disability policies, the Canada Pension Plan has a very strict definition of disability. I would say it is more strict than the one which Marilyn described for family benefits. In other words, if someone is disabled enough for Canada Pension, they can almost always or invariably get family benefits, but not necessarily the other way around. The three components of the definition are the disability must be severe, it must be prolonged, and it must lead to an inability to work at a substantially gainful occupation. Severe is quite a high test. Prolonged is defined in terms of the legislation as duration of at least 1 year. Substantially gainful occupation has been the subject of many decisions which are in the memorandum. There are policies of Canada Pension which are not generally published, but which are public documents and which can be obtained at the local Canada Pension Plan office. And there are certain guidelines and rules of thumb about how much you can work on a part-time basis or a limited basis and still be eligible for Canada Pension. But for purposes today, what you have to know is that Canada Pension disability is premised on an almost complete inability to work. And that in applying, if the person is working on a part-time basis, even very limited, or even engaging in training or education, or in some cases even volunteer work, Canada Pension Plan officials will take the position that that means they're capable of pursuing a substantially gainful occupation. And that also is a consideration if your client is receiving Canada Pension Plan and is considering rehabilitation, either in the form of training or education or return to work. You have to be sure that they understand the consequences of this, that they may lose their Canada Pension benefits. Also, if they are involved in any of these activities, they have a legal responsibility to inform Canada Pension Plan. Otherwise, there may be an overpayment generated if they're paid benefits and then Canada Pension finds out and says, well, you were going to school full time. That means you could have been working. You've been doing that for the last year. They will come after the client for a year's benefits. And certainly I've seen a number of cases like this. In terms of information about the Canada Pension Plan, as I'll just mention parenthetically, as the CRO memoranda which you have indicate, right on the first page, the Canadian Employment Benefits and Pension Guide reports contain a tremendous amount of information. I also suggest that you get office consolidation of the Old Age Security and Canada Pension Plan legislation and regulations from CCH. The legal reporter regularly produces this on an updated basis. The other issue for Canada Pension Plan is in terms of contributory requirements. These are extremely technical and again are well set out in the memorandum. I won't go into them in any detail, but just give you the basic concept. Essentially, in each year it is determined whether you have contributed to Canada Pension or not and how much. There is a minimum amount which is set quite low of earnings. This year it's about, well, last year was $3,200, so not very much at all. But that's the minimum that you have to earn in a year to have contributed. There is also a maximum, as many of you hopefully will become aware that you could at least earn that in practice in the current environment, beyond which you don't contribute to CPP anymore. So between those two earnings levels, there are different levels of contributions that you make. Contributions are only made from employment earnings or self-employment earnings. Now, so for each year, Canada Pension will have a record of whether you have contributed or not and how much. Essentially information taken from your income tax return or from your client's income tax return. A printout of the record of contributions is now sent, I think, about every 3 years to everyone who is in the plan, and can be requested on a more frequent basis, and this should be done on behalf of your clients. Now, to qualify for disability, there are quite rigid rules. It is essentially contributions in 2 of the past 3 or 5 of the past 10 years. In other words, to be eligible at all, the test is, has your client contributed in 2 of the past 3 years or 5 of the past 10 years from the date in which they can be deemed to be disabled. And this is just on a calendar year basis. So they're looking at basically, was the person in the workforce enough to earn more than, say, well, in 92, $3,200. It's an amount that has been increased steadily since starting at $600 in 1966. Now, what's the date at which you can be deemed to be disabled? Well, their rule is that it cannot be more than 15 months prior to the date of application. So you cannot go back in applying to the date at which the person actually became disabled. It can only go back 15 months, and then these rules are applied at that point. There are lots of complexities dealing with prorating for part of years, with the fact the rules have changed, and you may have clients who have to look at the earlier set of rules before 1977. There are lots and lots of complexities, and you have to look at the contribution rules as in the memorandum or as in the Act very carefully. And in terms of having minimum contributions, without explaining the rules, I'll just alert you to 2 or 3 things to look at. One is that Canada has reciprocal social security agreements with a number of other countries. A client who has worked in another country may have made contributions to their national pension plan, which can count. As well, there is a full exchange between the Quebec and Canada pension plans, and a client who has worked in Quebec and contributed will have his or her contributions in that province counted as equivalent to those made in the rest of Canada. Quebec is the only province with a separate pension plan, but there is a full reciprocity between the two. As well, for people who have dropped out of the workforce to care for children, there is the child rearing dropout provision, which means that certain years spent in where the child was under 7 in the home can be excluded from the contributory period altogether. So it's something else to look at, not only for women who are the usual caregivers or the actual caregiver, but if the husband was the lower income earner and claimed the family allowance, even if he weren't the actual caregiver, he still might be able to benefit. Also, if your client with a disability has been involved in a matrimonial breakdown, he or she may have eligibility for credits due to the complex credit splitting rules. In the most extreme case, although very few people I think would know this, a person who has not been in the workforce at all might still qualify for CPP disability if they had the credits through credit splitting. The credits achieved through credit splitting or division of unadjusted pension credits, to use the technical term, those credits can be used for disability pensions equally as for retirement pensions, and those obtained through credit splitting count just as much as from direct contributions through earnings. There is also recent legislation. In the system, if you apply too late, in the past, you would lose your eligibility altogether. There are now provisions that will assist your client in those situations. They fall short of full retroactivity, but it is now possible, if the client would have been eligible, say, if they had applied in 1988, but are no longer eligible now because of the 15-month limit, to still have their claim considered. They will get a lower pension, disability pension, than if they had applied in 1988, but they will still get some pension due to these special provisions. Again, they're outlined in the memorandum. Finally, if your client does get a CPP disability pension, in the typical case, it comes in a lump sum because there will be some retroactivity. And this has different consequences. Marilyn Marshall already touched on the family benefits implications. There can also be implications for long-term disability, in that the long-term disability insurer may have a contractual right to that money. Also, the Canada Pension Plan disability payments, like retirement pensions, are taxable. And if there is a lump sum which relates to more than 1 year, Revenue Canada is supposed to allocate it towards the years the payments really relate to, which will reduce the tax liability. That is supposed to be done automatically, but you should inform your client about it to be sure that it's done. As you may tell, I find this topic fascinating and could talk about it for several hours, but I hope I've at least highlighted or flagged some of the issues for you. I think the CRO has done a superb job at compiling the law in this area, and I'm glad you'll be taking away this resource with you if you see these issues in practice.
I'm told that if I mention course evaluations once more, I will be chloroformed, so I won't do it. I will say a final word of thanks to today's faculty and to all of you for your evident interest in today's subject.